Thanks, Angela. Good afternoon and welcome to session 2 of our post-employment massive open online course. My name is Patrick Shepard and I'm pleased to be joined today by Cheryl Kane-Piasecki. Welcome, Cheryl.
Thank you, Patrick.
So today, what are we going to dig into here?
Well, yesterday we sort of gave you an overview, a general overview of the primary provisions that we're going to be covering today and tomorrow. And then at the end of that overview, we assigned you out an exercise to sort of test how well you understand and can apply each of the elements that are in the provisions A1, A2. And so one of the things we gave you was a post-employment checklist for this employee called Ken Dickens. So what I would ask you to do is if you can have that handy, because we're going to peruse that before we jump into the worksheet. But then we've given you an analysis worksheet, which is kind of this process I told you about, an analytical process that we've given you to kind of help march you through or navigate you through the various and sundry provisions in A1 and A2. So if you can have that available and handy, we're really going to be working primarily out of this document today and out of the 2641 regulations. So I don't, again, as I say in all of these broadcasts, I don't really care what version of 2641 you're using, whichever one is most convenient and easy for you to use. We are going to be in 2641 a lot today. So
I always find it's useful to use the one I use every day because then if I want to make notes or otherwise mark something, I can do that and refer to those notes later when I actually have to answer a question.
Exactly. And we did give you the Federal Register version of 2641. And I'm going to be making at least a couple of references to parts of the preamble. And I'll try to give you the page numbers there. So if you want to go into the Federal Register notice that we gave you, you can do that and you'll see exactly where I'm talking about for future reference. But it's not going to be an inordinate amount of time in the preamble, but I'll make sure that you understand exactly where in the Federal Register notice I'm referring to.
Excellent.
Okay, so why don't we go ahead and get started? I hope everybody did have a chance to take a shot at the exercise. The objective of the exercise was to sort of, give you some verisimilitude of what, post-employment circumstances look like in your own agency, which is to say, to give you what looks to be a reasonably complete picture or as complete a picture as typically you can get of what someone's planning to do post-employment, and then to give you an opportunity to sort of work through the process, applying the law to the facts that you've been given. So I want to start by looking a little bit at Ken Dickens' post-employment checklist. He's given us some useful information here. He's given us his anticipated date that he's going to leave the agency, so we know how much time we're looking at. His most recent position, title, and pay grade. And as we mentioned yesterday, that is going to be useful for purposes of determining whether or not the person you're giving post-employment advice to is or isn't a senior employee. In our case, we're dealing with a GS-15. So Patrick, if we're dealing with a GS-15, are we going to have to deal with the senior employee restrictions of 207C?
Mercifully, I don't believe we will.
So that's one of the advantages too of, of being able to sort of eliminate from the get-go at least one of the provisions. So he's a GS-15. We don't have to worry about 207C. We know that right off the bat. He's given us a brief description of his duties, which we're going to come back to in a second. He's given us, in his case, he knows who his prospective employer is going to be. So that's
very helpful because sometimes we don't have the benefit of that information and we're sort of stuck with just beginning from the duties and responsibilities of the person while they were in government service.
And he's actually given us some anticipation of what he thinks he may be doing for them, which is kind of that's like gravy on your spuds, the more information obviously that your employees can give you, the more robust and fulsome your advice can be. So he's at least given us some description. And then we have at the bottom here, it's sort of a checklist of things that the employee was further asked to disclose. And I did this purposefully, and I borrowed some of this from some actual post-employment checklists that I've seen some agencies have. And what I tried to do here was to identify, based on the work area where Ken Dickens is employed, or that I have had him be employed, I did a little bit of research on what they did, and I tried to pull out certain specific party matters that people who work in that particular part of FDA might actually do. Because I think if you can give an employee more targeted questions, more pointed questions to answer, where you're almost helping them identify sort of the information you're most interested in getting, then it makes it much less of a back and forth, much less of a question and answer part on your piece of having to drag information out of your employee.
Yeah, I think that makes a lot of sense because they don't want to drag this process on any longer than you need to. They want to make sure that you can give them the right answer the first time. So, any tools you can use to get the right information the first time are very helpful.
And I know that that's a big ask when you're in a very large department or a large agency where you have, multifarious, duties and responsibilities and branches and things, and to try to craft a tailored, checklist for each and every, organizational unit. I'm not suggesting that, but I am saying to the extent that you could even broadly sort of ask people questions or pointed questions that would get to and help them understand that this is the kind of work we're concerned about, understanding whether or not you participated in. So when we look at Ken's checklist, Patrick, as an initial matter, we look at Ken's duties. And one of the first things he tells us is that he was responsible for drafting regulations regarding drug marketing and advertising. And then he goes on to say, I provided legal support to consumer safety officers in the compliance division in interpreting and implementing extant regulations in this area. So he's given us a little bit of a flavor for what he's done. So let's go to the worksheet now. And the reason I on this checklist put that information or ask for that information first is for the self-same reason that when you go to your analysis worksheet, your 18 U.S.C. 207 post-employment analysis worksheet, what's the very first question we ask? Did the employee have any duties that involve specific parties? Okay, so our very first question in our analysis process is we want to focus on the employee's government duties. Okay, so that's what we want to do. We're looking at the employee's government duties.
And Cheryl, it looks like we have a question coming in over the Hangout, and I think this says, is there a standard form for post-employment checklist available through the OGE site? And I don't think we have a standard worksheet for employees to complete on our website, but we do have the post-employment checklist, I believe.
The post-employment checklist, the checklist that we've given you here is available on our OGE. I'm not sure if it's on the website, but it's on Max.
It's definitely on Max, and I think it actually is under the section for ethics officials on the education tab of OGE's website. So if that's what you're looking for, it's available there, but also on the Max page.
If you're looking for a template for employee checklists, excuse me, I don't believe that we have that because it really wouldn't be something that OGE necessarily would be in the best position to do because for the very reasons that I suggested, that I think that the agencies that do have them have pretty much tailored them to their programs and their missions.
The kinds of work that their employees are going to do. In order to ask questions that are useful, we have to be familiar with the sort of responsibilities someone might have while they're a federal employee. And, obviously sitting here at OGE, we couldn't imagine those for the entirety of the federal government. But, if anyone wants to share the one they use at their agency as a template, we'd be happy to post it to the Max store on the Max site.
Absolutely. Okay, so when we go to the worksheet, the very first question we ask you to answer is, did the employee's duties involve any specific party matters? And this goes back to what we said about 207A1. What 207A1 is concerned about is prohibiting an employee from making post-employment communications or appearances with the intent to influence that are in connection with these things we call specific party matters that they actually participated in while they were government employees. So the key piece of information that we need to give post-employment advice is we have to know, did the employee work on any of these specific kinds of matters, these particular matters involving specific parties? Because if they didn't work on specific party matters, there is no 207A1 or A2 restriction.
And Cheryl, just so I remember, the specific party matters differ from particular matters that we might be familiar with from other parts of the ethics rules, and that these are the narrower set that deal only with named parties.
That's exactly correct. That's exactly correct. And in fact, I want us to get into 2641 because every time we're dealing with a key element, I want you to know exactly where in 2641 you can find it. So if you look in 2641, at 2641.201H. And for those of you who have those small blue compendiums, we're on page 676. I'm going to give you a minute to
Yes.
get there.
Yep, there we go. The particular matters involving a specific party or parties.
Mm-hmm. So it says, and I do want to alert you to this, because if you've looked at the statute, or if you've had other people that looked at the statute, there's some degree of confusion that can occur as a result of looking at the language in the statute. And H tries to help you understand that. So it says the prohibition in 207A1, this 201 is applying to 207A1, okay? Applies only to communications or appearances made in connection with a particular matter involving a specific party or parties. Although the statute defines particular matter broadly to include any investigation, application, request for ruling or determination, rulemaking, contract, controversy, claim, charge, accusation, arrest, or judicial other proceeding, only those particular matters that involve a specific party or parties fall within the prohibition of Section 207A1.
Oh, that's excellent. So we get some clarification about the significance of this definition in the statute and where and to what extent it applies for 207A1.
Exactly. And so the types of matters that are going to fall within the ambit of 207A1 and A2, it's the same provision. A2 restrictions are these specific party matters. They must have named parties. And they give us a little bit of a list, and we've seen this list before, which includes, what are some of the things it includes, Patrick? A little laundry list that we have there at the bottom of H.
At the bottom of H here.
Or H1.
H1.
Says a specific contract, grant, license, product approval, application, enforcement action, administrative adjudication, or court case. This isn't the universe, but this gives you a flavor for the types of particular matters that we're talking about. That would be the types that are going to trigger an A1 or an A2 restriction.
And again, what these all have in common is that they have named parties. These are matters to which you can be a party. So the things that we're not talking about here are things like regulations or rulemakings that affect a class of persons.
Exactly, because those are considered to be matters of general applicability. And we also discussed that in the regulation here as well, which is handy. So if H1 talks about specific party matters, H2 addresses matters of general applicability. And it states explicitly in the regulation, if we go to H2, it says legislation, rulemaking, or rulemaking of general applicability, and the formulation of general policies, standards, or objectives, or other matters of general applicability are not particular matters involving specific parties. So the regulation itself gives us a really clear understanding of what is not within the universe of a specific party matter.
And I find that to be very helpful, because in addition to telling us what a specific party matter can include, we also give you some hints as to what it excludes.
Exactly.
So when we're looking at these things that are identified in H2 here, we know that those aren't specific party matters. So for purposes of 207A1, we don't need to be concerned with them.
Okay. So armed with our definition out of 2641, we have to go back and look at what Ken told us. Okay. So we're going to look at what the duties that Ken briefly describes. And the first thing Ken said is, I was responsible for drafting regulations regarding drug marketing and advertising. Okay. Now, drug marketing and drug advertising, that's going to involve what?
Well, the drug companies, but as
drug
a group,
companies, right?
Yeah, as a class of persons, probably not specific to a single company.
Mm-hmm. So what's the word here that we look at that makes us immediately say this is likely not a specific party matter?
The idea that it's a regulation is very helpful. So we're not talking about an investigation or litigation or something like that. We're talking about regulations and policies.
Right. So unless this regulation is somehow very different from other regulations, which is to say, if it's a negotiated, some sort of rulemaking, which are very uncommon, I think. Typically regulations, policies, programs, if someone's working in those areas, those types of activities are not specific party matters.
So they're going to fall outside of our prohibitions in 207A1.
Exactly. So let's move on. Okay, he's got regulations that he's involved with. Okay, but regulations, unless we have information to the contrary, I would say those are going to be matters of general applicability. So he goes on to say, I provided legal support to consumer safety officers and the compliance division in interpreting and implementing extant regulations in this area.
That's a little more interesting.
Mm-hmm.
Because we're still talking about policies, but it's not clear if we're talking about the enforcement of the policy in an individual instance,
right,
or sort of more generally. So I think I would have a follow-up question here.
Mhm. So this would be exactly one area where you'd say, okay, what is the nature of the legal support that you're being provided?
Right.
To whom are you providing the legal support? And most importantly, in connection with what kinds of things?
What kinds of things? So, for example, if Ken was participating in an enforcement action, so someone is alleged to have violated these regulations, and we're doing an investigation, and he's providing support to the investigation, that investigation would probably qualify as a particular matter involving specific parties.
Right. And so this is where our handy dandy table at the bottom of Ken's checklist does come into play. This the questions that are asked in the bottom part of this in the table are things that you certainly can go back with a live sort of Q&A with your employees, but it's also something you could consider asking them in advance to try to get that information before you wind up having to have an exchange with the employee. So among the questions that get asked in the bottom here are, have you or has anyone you supervise participated in compliance monitoring involving this company? And the answer that he gives is yes, that he himself was involved in, it says Wellness Pharmaceutical, which is his prospective employer actually,
right,
was cited for marketing and advertising its drug Wellarest for additional uses beyond those for which it received FDA approval. I provided legal review support to the investigative team. What's the triggering thing there, Patrick, that makes your ears stand up?
The notion of an investigation, I think that's explicitly included in our definition of specific party matters. So when we get to the investigation of potential wrongdoing or violation of a policy, the fact that we're talking about a policy ceases to be the important fact. And the important fact is that it's an investigation, and there are indeed parties to investigations.
So in this instance, we know that he's been providing legal support. We know that he's been involved in drafting regulations. Now we know that he's been involved in providing legal support to interpreting those regulations in the context of an investigation. So it's that the thing that really we needed to hone in on was, aha, now I have an actual specific party matter. I can put my hands around a specific party matter that involves his provision of legal services. And that specific party matter is
the investigation.
The investigation.
So he's participated in that, even though he's not going to be the deciding official. He's merely providing support, providing the legal support in the context of the investigation is participation in a specific party matter.
Yes. Well, So we know that we've got a specific party matter that was something that he was involved in.
Right.
So the answer to our first question is, did the employee's duties involve any specific party matters? The answer to that is yes. And then under 2, we're asked to list what the specific party matters are. And in this case, I think it's the investigation of wellness appears to be the only specific party matter we have for Ken.
Excellent.
So, but it's not enough. We don't stop there because, okay, we've identified specific party matters. So now we know, okay, there is something out there for which he may wind up having an A1 or A2 restriction. But now we've got to figure out whether or not his restriction is going to be an A1 restriction or whether it's going to be an A2 restriction. And for purposes of A1, we need to know what kind of participation did he undertake in the context of this investigation. And specifically, we need to know whether he participated personally and substantially in the investigation, okay? So let's look at what he told us, and then let's go look at the definition of personal and substantial participation, okay? So what did he tell us? He said that he provided legal review support to the investigative team. What in your mind, Patrick, might that have involved then? I mean, just sort of as a general proposition.
Yeah, no, I could imagine him having meetings and consultations with those people who are on the ground doing the investigation to help clarify for them what the rules require or what they prohibit, so that they can better determine whether or not this party was either in compliance or violation of those rules.
So at the end of the day, one would assume that at least in part, some of his legal support was making determinations about whether or not they had actual violations that would then have to be adjudicated, right? Through some mechanism. So let's look at personal and substantial participation, the definition.
Let me see. So I see it on page 681 in the top left.
Okay, and that is at 2641.201I.
Well, that's a rather long definition.
It is a very long definition. It's a very long definition. But I want to we'll move through it quickly because it does have constituent parts. But I do want us to understand what it means to participate personally and substantially. Okay, so to participate means to take an action as an employee through decision, approval, disapproval, recommendation, the rendering of advice, investigation, or other such action, or to purposefully forbear in order to affect the outcome of a matter. This purposeful forbearance, I'm going to come back to in a minute.
Okay.
But let's just focus on the first sort of litany of things there, okay? Deciding, approving, disapproving.
Yeah, that makes sense to me. Obviously, that's going to go to the substance of the specific party matter. That's participation in the way that I think I would understand it, absent this definition.
But we don't just stop there, and we don't stop at just final decision-making or final sort of determinative sort of actions in a matter. What else do we incorporate?
No, I find this a little surprising, but this is really good to know that the rendering of advice or merely making a recommendation can constitute personal and substantial participation.
Exactly. So the types of ways in which you can participate can trigger personal and substantial well before the matters reach a final decision-making point. Okay. So we're looking at from the beginning of the genesis of a matter until it is finally approved and acted upon and it's effectuated. There's an awful lot of participation.
Right, and many people could be involved in this participation. There's a lot of opportunity to participate, even if you're not the final decider, or even if this isn't a matter that belongs sort of to you as an assignment.
Exactly. So that we know that that's the laundry list here. The purposeful forbearance, I think, is an interesting addition, and it's only in 2641, I think, where you see this. And effectively, what this is saying is that inaction that is known to affect the outcome of the matter, e.g., by not acting on it, you are materially affecting the outcome of the matter, can also be considered to be participation, even though that seems contrary to rational thought. So this
would be something like, you receive an email and says, unless you do something, we're going to move forward with this.
Right.
And then you decline to do that thing, and knowing full well that the matter is going to move forward without your participation. You're still participating.
Yes, or if you elect to not act on a matter and the result of that, and the result of that will be that, for example, you miss a deadline or something expires as a result of it. So simply by refraining from acting, you have, in effect, decided the outcome of it because, outside factors were affecting them.
Right.
Mm-hmm. So that's what we mean by purposeful forbearance there. Now, one thing I wanna also underscore here is that it doesn't include things like having knowledge, merely having knowledge of the existence of something. That's not going to be sufficient in order for you to have actually participated in it. So in order to trigger personal and substantial participation, it doesn't have to be determinative of the outcome, but you have to directly participate individually or in combination with other people. And this is at I2, or, and this is where I think it's interesting for supervisors, through the direct and active supervision of any person he supervises, including a subordinate.
So this would be like if you're asking for frequent updates, you get a briefing once a week, you're directing people to put their emphasis here or there, looking after the timeline, that kind of direct and active supervision. So you're involved by way of supervision in this case.
Exactly. So in our instance, I think when it comes to the personal piece of it, I don't think there's any question that Ken has participated personally in this matter.
Yeah, I think so.
Okay. So then the question does become about the substantiality piece. Like, how have you participated substantially? And when we look at this, I think it's important to think of this as a qualitative versus a quantitative concept.
So it's not about how frequently we participate. We could participate for a very short period of time or for a very specific purpose. And still participate substantially.
Absolutely.
Okay.
And the definition pretty much tells us that. It says it means that the employee's involvement is of significance to the matter. It may be substantial even though it's not determinative of the outcome, but it requires more than official responsibility, knowledge, perfunctory involvement, or involvement on an administrative or peripheral issue. Now, this is where it gets key. to be substantial, it has to be based not only on the effort that the employee puts in the matter, but on the importance of the effort.
So it's the nature of the participation that makes it substantial, not the volume of participation. So you could do a lot of administrative support on a matter, and none of that could go to the substance of the matter. Right. However, you could make maybe in Ken's case a single recommendation, or have a single meeting to clarify a substantial point of the rule, and then we would be into substantial.
Yes. Exactly. So you can trigger personal and substantial at any point in time that you're actually being engaged or being asked to participate in it. And that's why we say that that personal and substantial participation, it's a very low threshold. When we go back to the slide, we can do that. That it's a very low threshold. So in the case with Ken, if we take that sensibility about you have to participate directly, and then your participation has to reach to the substantive merits of the matter.
Right.
If he was providing legal support, legal review support to the investigative team, does that meet that threshold? That
seems to be of substance to the matter. I don't think we could say that was merely ministerial in nature. He's providing some expertise and sort of substantive understanding and making substantive recommendations about what the rule does or doesn't require.
Now, does it matter then, Patrick, that let's say, because Ken was a 15, but let's say that there were people above him in rank and pay who were ultimately going to be deciding, or like even reviewing Ken's work and deciding whether or not they agreed or disagreed with Ken's legal analysis. Does that then transform his participation from personal and substantial to something else?
It doesn't seem that it should. If he's participated, he's participated. If someone who is the final decider or approving official decides to disagree with his recommendation, that doesn't undo the fact that he's made a recommendation.
Right, exactly. So his recommendations and rendering advice don't have to be taken or ultimately show up in the final analysis. It's the fact that he has contributed those, that he has actually participated in that way, that it triggers personal substantial participation, okay?
I think that makes sense, but it's important to think about and remember that, because it doesn't strike me as tremendously intuitive. So it's a place where we just want to be careful.
And I think it's a lot of places where you're going to get not only pushback from people, but you're also not going to get people owning up to having participated in a matter because they don't realize that they didn't have to be the decider. They didn't have to be making the final approval, that their participation constituted personal substantial participation just because of the nature of the input that they were providing.
So maybe when we're talking to employees and trying to gather information, it might be good to either explain these sort of terms of art in the regulation or ask broader questions and then narrow down what kinds of participation constitute personal and substantial. So for example, if I was talking to Ken, I might just ask him if he had worked on or had any meetings regarding any specific party matters. Then he could tell me what he did, and I can then determine whether or not his participation is personal and substantial or if it's merely ministerial.
Right. And that is one of the key pieces, that you have to make this intelligible to people. If you start throwing around nomenclature like personal and substantial participation in specific party matters, you're going to get blank stares and you're not going to get a good set of facts. So I think obviously the more that you're comfortable with these terms, that you can translate it into common English for your employees, the better the facts are that you're going to get, and then the better the kind of guidances that you can give your employees.
And I'd like my facts always to be over-inclusive rather than under-inclusive of the information that I require.
Right.
Because we are in a better position to sort out those facts that aren't relevant than the employee is.
Right. So we've established that he participated personally and substantially. And once someone has participated personally and substantially, the bottom line is that A1 is going to trump A2. So if you know that someone has participated personally and substantially in a specific party matter, they have an A1 restriction with respect to that matter. And you really don't have to answer the question, was it pending under their official responsibility? Because A1 is a permanent bar and is going to extend beyond what would be the 2-year disqualification or like no communication bar under A2. But for learning purposes today, we're going to go ahead and we're going to look at the whole notion of when would something be pending under someone's official responsibility had they not participated in it personally and substantially. So what I want you to do then is let's go take a look at, now we're going to be moving over into the different subpart, because the provisions for A2, which is this pending under official responsibility is the trigger for A2, are going to be in 202. So if we go to 2641.202J, that's going to tell us what constitutes official responsibility. And it's not a very satisfying definition, folks. So I'm going to try and sort of translate it for you, but I think it's important to know where it is and to see how it's written. Okay, so it says official responsibility means the direct administrative or operating authority, whether intermediate or final, either exercisable alone with others or either personally or through subordinates, to approve, disapprove, or otherwise direct government action. Okay?
You're right. That's not tremendously clarifying upon the first read.
Yes. Basically, what this is saying is you have to have the ability to direct the actions of other employees. So this is trying to get at folks who have authorities to direct the action of other employees. So these are going to be your supervisors and your managers and people who are within a chain of command where they actually have people underneath them who work for them and, you know, who are accountable to them.
Right. They work under this person's official responsibility. So that's what we're getting at here, what it means to be officially responsible for the work of another.
Right. And my understanding is that they have to have actual authority to do that. So if you have someone who has some sort of informal leadership role, like a team lead or something, that's really not what we're trying to get at. We are trying to get people who actually have official authority to direct the work and the actions of other employees. So that's the first thing. Now, ordinarily, the scope of the employee's official responsibility is determined by those functions assigned by statute, regulation, executive order, job description, or delegation of authority. That's kind of getting at what I just said.
Right.
But this is the kicker. This just shows you how much stuff gets captured
under someone's
official responsibility. You want to read that piece for us, Patrick, if you can, all particular matters?
All particular matters under consideration in an agency are under the official responsibility of the agency head, and each is under that of any intermediate supervisor who supervises a person, including a subordinate, who actually participates in the matter or has been assigned to participate in the matter within the scope of his official duties.
Yeah.
So this could be a really long opinion in the case of a very senior official or someone that's high up in the organization.
Absolutely. So what this is saying is anyone who's in the chain of command is going to, the farther up in the chain of command you go, right, the more things you have pending under your official responsibility. Now, in actuality, in terms of the communications backed, I mean, the prohibition reaches to in which you reasonably knew or reasonably right, should have known was pending under your official responsibility.
Right. But you could learn that in both directions, right, Cheryl? So, you know, while I was responsible for it at the agency, I may not have been aware that, I don't know, say contract X was pending at the agency when I was responsible for it, you know, through some attenuated chain of authority. Mm-hmm. But then when I go and take a job with the contractor, and I know from that perspective that that contract was pending during my tenure, I should reasonably know that I can't represent back on that. So that's pretty tricky.
It is tricky because it's at the time of your post-employment communication or appearance, did you know or reasonably should have known that the matter was pending under your official responsibility?
Right.
So yeah, so it is tricky that way. So just so that everybody's sort of clear on that, you know, when you're talking to your agency head or you're talking to your senior employees, they need to be meant to understand that this A2 restriction is going to reach to not stuff that they personally worked on, but stuff that they knew that was pending within their chain of command during their last year of government service. It's only a 1-year look back from the date they terminate service. So within the last year of government service. So that mitigates it a little bit.
Right, but that also provides us, you know, for those officials who are high up in the chain, who have a lot of subordinates under their official responsibility, a practicable way of applying this restriction.
Right.
Right. Because we can advise them that if they are asked to make a representation back to the agency on any specific party matter, you know, that we can help them determine whether or not that was pending under their official responsibilities.
Right.
Right. And we can do that after they leave the service. Right.
So the last piece I want to touch on here, because I think it's important to know this too. It's the very last sentence there. It says a non-supervisory employee, okay, a non-supervisory employee does not have official responsibility for his own assignments within the meaning of section 207A2. So this again clarifies that if you are not a supervisor or you are not a manager, the mere fact that you've been assigned something doesn't then encumber you under both A1 and A2. You know, if you're a non-supervisory employee, things that you're given to work on are not under your official responsibility for purposes of A2.
So we just look and find out if you participated personally or substantially. And if you didn't, then that's the end of it. We don't have to decide, well, does that technically make it under your official responsibility? Yeah, I think that makes sense to me.
Right. So when we go back to look at Ken Dickens, so let's just go back and sort of summarize that. And then I'm going to open it up for questions, for any questions that anybody has for these particular pieces that we've just touched on. But so just to reiterate, we identified from Ken's checklist that really the only specific party matter we were able to identify was this wellness investigation. Once we looked at that, we said we did think that Ken participated personally and substantially because he provided legal review support, and we think that met the threshold of personal and substantial participation. He has given no indication that he's a supervisor. So we really didn't, unless we knew that he was a supervisor and had reason to believe that he had supervisory functions with respect to this matter, we would have gone to A2. In this instance, we didn't go to A2 for two reasons. One, it's not clear, he isn't clear that he had any supervisory responsibilities, okay? But second of all, if you do have an A1 restriction with respect to a specific party matter, that's the big trumping authority, and you really don't have to consider A2.
Right, because that is going to be a ban for the lifetime of the matter.
Right.
So, you know, the temporal restriction will be sort of subsumed under that.
Right. Okay. I know this is the very preliminary part of our analysis here, but I kind of want to give people a chance to ask questions about anything that we've discussed so far before we move on.
And again, those folks who are on the Hangout, you can use the question and answer app in the bottom right-hand corner of your screen to type as a question. And Angela, if we could open up the phone line for any questions we might have now. See, I'm not showing any questions on the Hangout. Do we have any questions on the telephone?
Angela? You ready to open up for questions?
Yeah, if we could open up for questions for just for this section, yes.
All right. As a reminder, to ask a question, please press *1 and record your name clearly. Once again, to ask a question, please press *, then 1.
And it looks like we do have a question coming in over the Hangout. Okay. And Michael Hoyle asks, Max, a non-supervisory GS-12, works for government agency as an engineer. He is not responsible for drafting of requirements for or the post-award administration of an acquisition as a technical expert, nor a COTAR. And the question is, you know, could he be personally and substantially involved for Section 207? So it says he's not responsible for drafting of requirements. So I think the question is, do you have to be responsible for the requirements drafting to be personally and substantially involved in a contract as a specific party matter, or the administration of the award or an acquisition? Or there are other ways that you could be personally and substantially involved?
I think as a general proposition, I'm not entirely sure what is involved in drafting requirements, and that I would assume those are things that, I mean, if you're drafting requirements for the acquisition, then clearly I think you're personally substantially involved. Just not having participated in that particular aspect does not, in my mind, obviate that he may have otherwise participated in some way that was personal and substantial. So.
Yeah, I tend to agree. It seems to me that, you know, those things that you've identified, Michael, certainly would likely constitute personal and substantial involvement, but those aren't an exhaustive list of ways in which someone could be involved. For example, making a recommendation on behalf of a business unit for what a procurement should include or what the requirements ought to include could constitute a recommendation or personal and substantial involvement here.
A review, you know, or even if he wasn't drafting the requirements, if he contributed to a list of things that the drafter should consider including in the requirements, that might be sufficient to constitute personal and substantial participation.
I think, again, here, this is an important place where the function of the definition is very useful. What we want to do is know what it is that Max did on the matter.
Mhm.
And then we could look at that level of involvement versus the criteria in our definition to determine whether or not it constitutes personal and substantial participation or involvement.
Right, right. So I don't know if we've answered your question, but I think at the end of the day, those two, I think, the two areas that you've identified, I think, I don't want to say they're slam dunks, but I would say probably more often than not, engaging in those, clearly you're doing personal and substantial participation. But again, as Patrick said, I think there are things short of those enunciated duties, or in addition to those enunciated duties, that could also be personal and substantial participation.
And I think one of the things that I was sort of pointing out before that I think is really important, in an area you can go wrong here, is in reinforcing the perspective of employees that if I didn't participate in X, Y, or Z way, I don't have to worry about it.
Right.
What you want to know is, where, what kind of participation were you engaged in?
Mm-hmm.
And then you can look at that specific activity to determine whether or not it's covered under the definition of personal and substantial.
Exactly. Do we have any questions on the phone?
At this time, no question.
Okay, very good. Okay, well then I think we're going to move on to the next.
Actually, it looks like we have a clarification on that question.
Okay. Mm-hmm.
So what if Max was working on the contract only in the post-award phase, with other government employees or and contractor employees? So if is there anything magic about the post-award period that could take Max's participation out of the personal and substantial range?
I don't think so. And no, I don't think that there's anything that's magical about the post-award phase that makes it suddenly that you don't have to worry about someone's participation, or that we're only concerned about post-employment restrictions reaching to pre-award activities.
Right. The specific party matter persists for the duration of the
Mm-hmm.
contract. So any substantial participation that's personal in nature
Right.
would constitute involvement for purposes of 207A1 and A2.
Exactly.
Excellent.
Exactly. That's an excellent question, though. And I'm sure that's one you get quite often.
Yeah, and I think, this is where it gets really hard, because you say, well, that's a lot of people involved in this matter. And the answer is yes, that's a lot of people involved in this matter.
Mm-hmm.
And for each of those people, they could have, restrictions after they leave government service.
Mm-hmm. Because remember that the restrictions on the post-employment restrictions aren't the same as 208. So we're not just concerned about affecting the award of the contract. I mean, with 208, we're concerned about making sure employees don't participate in the award of the contract if they have a financial interest that could be affected by the contract. And clearly, probably the largest or most substantial financial interests are going to occur pre-award. And once the award is made, yeah, you can still have financial interest, but they wouldn't be quite the same. They'd be mitigated maybe on some level. With the post-employment, we're concerned about not switching sides on the same matter. So if you are working on the contract for the government in the capacity of fulfilling that contract or whatever it is that you're doing, you're working on that same particular matter for the United States government. And what the post-employment restriction says, well, then you can't then go switch sides on this same matter while that same matter is ongoing, and now be communicating back to the government, but be representing the other party side of the matter.
And actually, we have another question that's come in over the Hangout, which is kind of interesting. And this suggests, if you're a procurement director in this
Mm-hmm.
case, and you are responsible for a number of contracts, you supervise most of those contracts directly through hands-on supervision and
Mm-hmm.
participation. But in one case, you have delegated all responsibility for it to a subordinate.
Mm-hmm.
How do you parse that? Would that put you in A1 land or in the cooling off?
Mm-hmm. If you are a supervisor, whenever you are directly and actively supervising an employee, that's considered to be personal and substantial participation. If you assign it off down your chain to other subordinates or to your subordinates, and you are not in any way directly or actively supervising it, such that you could be considered to be personally substantially participating, you may not have an A1 restriction, but you're still going to have an A2 restriction. Right. Because you cannot, the fact that you're not participating in it yourself only takes you out of the realm of the personal and substantial participation. If it remains within your chain of command, even if you don't touch it,
you can't sort of divest yourself of official responsibility
exactly.
through delegation. So if the people who are working on it report to you, you're officially responsible no matter the degree to your involvement. In fact,
Mm-hmm.
you could not be involved at all.
Mm-hmm.
But if they're in your chain below you, you're still officially responsible.
And
right?
The regulation explicitly says in the A2 restrictions, it explicitly says that you cannot recuse yourself out of an A2 restriction. So if you have an employee who's a supervisor who's decided that they want to go work for, let's say, a contractor on a contract that they know is pending in their shop, in their organizational unit, and they say, well, I'm not going to participate in this because I'm seeking employment with this organization or whatever. So my deputy and those subordinates are going to do it, and I'm going to be carved out of it, and I'm not going to work on it at all. Okay, well, you don't have an A1 restriction, but you still have an A2 restriction.
You still have that A2 because you can't divest yourself of official responsibility simply by delegating.
So you would either need to have that matter moved completely out from underneath your organizational unit, or you yourself would have to be removed from that organizational unit in order to get out from under that A2 restriction.
Excellent. I think that's an excellent answer to the question.
Okay, so let's go on to our next issue, which is what we need to do. We know what duties our employee performed. Now we need to know, do we have any sensibility at all about what this employee is going to do for their prospective employer? So we're looking to identify any post-government employment or activities. And Ken has helpfully obliged us. Bless his heart. He's told us that he's going to go work for this pharmaceutical company, Wellness Pharmaceutical, and it's like ding, ding, a ding. I mean, that sounds vaguely familiar. That's the one that we investigated. Okay, which raises a seeking and negotiating for employment question, but we're not going there today because we're dealing with post-employment.
We did that 2 weeks ago.
We did that 2 weeks ago.
Questions about that? You can go back and look at our broadcast from 2 weeks ago.
Okay, so under 6 on his checklist, he says he's going to be legal counsel for wellness. Okay. He's going to coordinate their regulatory program. Okay. Which is going to include reviewing and approving documentation that will be submitted to governmental regulators. Okay. He's going to be the point person for all communications regarding compliance with regulatory requirements in the areas of marketing, advertising, and communications. Okay. So there are a few things here that I think we need to sort of like be thinking about, which is, okay, do any of these matters concern us from the standpoint that they might involve, the kinds of prohibited activities, the things we know he's going to be prohibited from doing if he's got an A1 restriction, which is that he wouldn't be able to communicate, he wouldn't be able to appear before the government. Do we have any sensibility about this, that those are the kinds of activities that he's likely going to be involved in?
I'd want more information, but there's certainly some phrasing here that causes concern, right?
Well, regulatory program, your documentation to be submitted to governmental regulators.
It seems that the likelihood that he might be asked to communicate with the agency is not insignificant.
Right. So, but as we recall from our overview yesterday, when it comes to A1 and A2, we're only concerned about those types of communications or appearances that are done in conjunction with what, Patrick?
With the same particular matter. So again, we're going to have to go back and find out if that specific party matter he participated in as an agency employee is ongoing, and find out if his communications might be in conjunction with that matter, not just communications in general. Is that right?
Exactly. So I think one of the first things we want to hone in on here is this wellness investigation. So what we want to find out from the employee is the investigation over? Is it still ongoing? Is it a live thing, or is it something that is been completed, is done, is over with, is good to go?
Right.
Because if it is done, then
it's impossible for him to make a communication in conjunction with the same particular matter, because the particular matter doesn't exist anymore.
That's right. The same particular matter would not exist anymore. If it's done, it's done. If it's over, it's over. Let's say, though, that it's not. Let's say that for whatever reason, it's still open, that maybe they have just only reached their findings that, let's just say for argument's sake, they've only just reached their findings that wellness is in non-compliance with the regulation.
Okay, so it's an ongoing investigation. It's something that will persist into his period of employment with wellness.
He's told us that he's going to be the point person for all communications regarding compliance with regulatory requirements in the areas of marketing, advertising, and communications.
That would seem to put him at risk for making communications in conjunction with that investigation if it's ongoing.
Exactly. So the confluence of facts between what he did in the context of the wellness investigation, which the wellness investigation was addressing marketing and advertising compliance issues, and his job with wellness is going to be communicating regarding compliance with regulatory requirements in these areas. marketing and advertising. So I think we've got a nexus here so that we have to now be thinking, this is one place we're really going to have to target, and we're going to have to make sure that Ken understands what he can and cannot do for wellness, particularly with respect to this matter.
This particular matter.
Right.
Involving specific parties.
Okay. So,
And this is the operator.
yes.
Do you have a question?
Okay, sure.
Excellent.
Oh, thank you. Jim Robertson, your line is open.
It's possible your agent has a slide. Yeah.
Hello? Do you have, is there a question?
Really gonna have to target, and we're gonna have to make sure that you can understand what you can and cannot do for wellness, particularly with respect to this matter, this particular matter, right, involved.
We're having a little trouble hearing you on the phone. If you're on speaker,
Okay, sure.
Hi,
guys.
Yeah.
yes, if you could turn the volume down on your computer, it'd be helpful.
Hey, can you guys hear me?
Yes,
Can
but
you turn the volume down on your computer?
Sure. Yeah, how about now?
That's much
That's
better.
better. Thank you.
Okay, so I was trying to get in earlier on the question section.
Sure.
Sure.
My question is it possible to have a specific party matter created between federal agencies, as in an interagency agreement?
No, an interagency agreement would not be considered to be too specific. It would not be a specific party matter.
Just to repeat the question for the folks on the Hangout, the question was, would an agreement between two government agencies, could that constitute a specific party matter for purposes of 207?
No, and it's the government having a conversation with itself. So it wouldn't involve parties outside of the United States government. So those types of matters would not be deemed to be the types of matters that are subject to the 207 A1 and A2 restrictions.
And this is one of those cases where we sort of abide by the legal fiction that the government's interest is singular. So the government, even if it's represented by two different agencies, is still just one party.
Mm-hmm.
Excellent. Thanks. That's a very good question, though.
Great. Thanks, guys.
And it looks like we have another question up here on the Hangout. Matthew would like to clarify that the particular matter is only the citation investigation itself, as opposed to oversight over the advertising practices relating to the particular drug well arrest.
That's correct. And this is where we have to be careful about defining the universe of what constitutes the particular matter involving specific parties. We addressed this a little bit in what constitutes the same particular matter. And I think that's really where the question comes into play, and the part of the regulation that you should probably look to when you have those kind of questions about what is the reach of the particular matter, at least in part. So if we can find the same particular matter is defined in 2641.201. This is where it gets hairy. H5.
There we go. I have it on page 679, top right corner.
So it says it's only going to, the restriction is only going to apply to the same particular matter involving specific parties in which the employee participated as a government employee. Okay. It says the same particular matter may continue in another form or in part. In determining whether two particular matters involving specific parties are the same, all relevant factors should be considered, including the extent to which the matters involve the same basic facts, the same or related parties, related issues, the same confidential information, and the amount of time elapsed. Okay.
Okay.
Now that's kind of a general thing. So let's go back to the sort of the question you were asking and the way that you framed it, and talk a little bit about our wellness investigation. The wellness investigation is obviously triggered by an event, and the agency has processes and procedures for deciding when an investigation is triggered.
Okay.
And so once the investigation begins, the investigation is the particular matter involving specific parties.
Right, because
okay?
that is the thing to which you can be a named party.
Right.
You're a party to the investigation.
Now, here's where it's really I think it's agencies, you are all gonna have to be trying to make these determinations for yourself, and we're happy to try to help you. But at the end of the day, OGE defers greatly to agencies to be sort of deciding when a particular matter involving specific parties kind of ends, or depending upon the nature of that process, how many additional things are still a constituent part of that ongoing investigation. So let me give you, for instance, let's say that in the wellness investigation, the initial piece is that you have to do obviously your research and go out and do your original, questioning people and doing whatever, and that a report gets written and the findings get evaluated and legal determinations are made based on those findings. And then a report is issued to the company, let's say, outlining all of the findings and recommendations for ways of ameliorating that.
Okay.
It might very well be that once the report is issued, that according to your agency processes, that investigation has ceased. Or it could be that no, it's that you have authorities to further follow up. It's not just enough that you report out, that part of your investigation is making sure that there's an enforcement action taking place and that they comply with all recommendations. So it could be that actually the investigation includes not just the issuance of the report, but each subsequent follow-up that might include additional audits that will ultimately result in an ultimate exoneration or an ultimate removal of recommendations. And so the investigation, that same particular matter, involves all of that. It involves the initial, the report, the additional findings, the follow through, the monitoring of compliance with the recommendations. And really, it's going to be up to you all to decide and to know for yourself, how confined or how expansive your particular matters involving specific parties are.
Right.
But I guess what I would suggest to you is, but that's separate and distinct from having an overarching regulatory regime that requires you to routinely make sure people are complying. The regulatory compliance program is not the same thing.
It's not a specific party matter.
As the discrete investigation.
Right.
So you can have discrete specific party matters that exist within the realm of an overarching program or
and those
initiative.
Could be very numerous, but each being distinct from one another. So if we have a rule that applies to an entire industry and we are investigating various members of the industry, each one of those investigations is a separate particular matter involving specific parties,
right?
And we treat them separately. Actually, we have another question that I think will also help to get at this question. And the question is, in the case of a very long ongoing contract, say, for example, we had a contract to construct, maintain, operate, and then deconstruct a facility for a particular purpose. And this takes place over decades. Is that contract the same specific party matter throughout? It seems to me the parties are the same.
It depends. It really, really depends. And I'm so glad that you asked this question, because first of all, I want to make 2 points with respect to contracts. By large and in the main, OGE's perspective on this over the years has been a contract is a contract is a contract, which is to say a contract is a singular thing. And even if it contains a bunch of constituent parts, it is all the same particular matter involving specific parties. Historically, OGE has taken that position. We've moved away from that position somewhat, and we do discuss it in the regulation, and we talk about it specifically with respect to what we consider to be large umbrella type contracts, things that can be like IDIQ, indefinite delivery, indefinite quantity types of contracts. That in those kinds of large umbrella or IDIQ type of contracts, and I'm sorry, this is at 2641.201 H5 2i C. Where we were talking about same particular matter at 5(1) if you go down that page a little bit further to C.
So under considerations in the case of contracts, grants, and other agreements.
Yes. Paragraph C, it says a contract is almost always a single particular matter involving specific parties. However, under compelling circumstances, distinct aspects or phases of certain large umbrella contracts involving separate task orders or delivery orders may be considered separate individual particular matters involving specific parties if an agency determines that articulated lines of division exist. So in the first instance, if you have one of these types of umbrella types of contracts that is, let's say that the way that it's actually functioned out is through separate and distinct task orders. that it's basically just kind of a, this does everything from soup to nuts. This contract is going to give us everything from administrative support to, the Mars rover. That is what we mean by like an umbrella type of contract. And very often with those types of contracts, underneath that, each specific aspect of the contract is done through discrete task orders. We're saying those types of contracts, you all can make some determinations about whether or not you feel that those should be separated into distinct and separate specific party matters, and they are amenable to that.
So we give agencies some flexibility, or we ask that agencies find if there are significant divisions that exist to separate those large contracts into smaller specific party matters for purpose of this part.
Yes, but we are very specific about that. And we're not saying that just because it's a big contract that has a lot of pieces to it, that necessarily is going to be sufficient to qualify it for this segregation sort of provision. With respect to the 20-year length of the contract, I don't think the duration of the contract is really material. What we do say, if you look in paragraph A, is that if you make amendments, modifications, or extensions of a contract, that's typically not going to be enough to make it a new particular matter involving specific parties. So if over the course of a 20-year contract, you have these slight mods that go onto it, or you have different extensions of it, those things aren't going to be sufficient to make it a new particular matter involving specific parties.
So this is kind of another case where the regulation and the law require agencies to consider all of the facts and make some judgments about the facts.
Right.
We don't have a lot of categorical determinations that, a contract is necessarily the same specific party matter, or an investigation definitively ends at this juncture of the phase. We're asking agencies to consider all of the factors. We give the factors that should be considered, but ultimately it's the person sitting in the chair of the ethics official and the agency as a whole to make those determinations. Right.
And likewise, in paragraph B, we say that once a contract terminates, even if it's effectively the same contract but it gets recompeted, once a contract expires and is recompeted, that recompeted contract is a new particular matter involving specific parties, even if it looks identical to the expired contract. And we do see that a lot sometimes.
We do see that quite frequently.
So the critical piece there is that the contract expired, it was recompeted. That expiration plus recompetition means that those two contracts, even if they were virtually identical, are two separate particular matters involving specific parties.
So this is a case where we can tell you what isn't the same particular matter, but where you have a contract that may comprise multiple particular matters. That's something you're going to have to consider the facts carefully.
And I do ask you please to take a really close look at the regulation, read the provisions in there in the regulation, and the preamble has an awful lot of additional information in this area because we know this is one of the trickiest areas.
Yeah, before the regulation, I remember we used to get these questions all the time, and a lot of thinking had to go into them, and a lot of thinking went into this part of the regulation.
Okay. So let's move on to we're concerned that we think we may have the same particular matter involving specific parties here with Ken. So now we have to be able to tell Ken what Ken can or cannot do for wellness in connection with this wellness investigation. Okay.
Okay.
So the first thing we have to understand is that this is an appearance or communication bar. So, but what does it mean to appear or to communicate? So let's take a look at the definitions of communication or appearance, because they may seem obvious on their face, but as with everything in regulation land, nothing is ever as obvious as we think. So if we look under 2641.201 D, okay, so if we start with communication, now notice we're saying appearance or communication. So clearly these are two distinct things, okay? So what's a communication, Patrick, generally speaking here as appear?
A former employee makes a communication when he imparts or transmits information of any kind. So this includes facts, opinions, ideas, questions, or direction to an employee of the United States. So that seems to be if you say things or otherwise communicate them. So I don't think it has to be verbal communication. It could be in writing or otherwise, right?
So it can be through any medium, any mechanism or whatever that that a former employee is actually transmitting information of some sort to an employee of the United States. Now, the next sentence is the kind of tricky one here, and we're going to spend a little bit of time on what this means. So the next sentence says, this includes only those communications with respect to which the former employee intends that the information conveyed will be attributed to himself, although it is not necessary that any employee of the United States actually recognize the former employee as the source of the information.
So it goes to the intent of the communicator,
Right.
not the experience of the recipients of that communication.
Exactly. And it's clear here, we're saying that this includes communications. So if the former employee intends that the information be attributed to himself, but it doesn't have to be clear to the government that it's coming from this person, what is that suggesting? It's suggesting that the communication isn't actually coming from
the employee necessarily, or the former employee.
Right, but is coming through?
Maybe through an intermediary.
Exactly. So we have to be concerned about communications that are not only the direct communication by the employee, but that the employee may be imparting through a third-party intermediary. And this gets a little dicey because the bar is supposed to be on appearances or communications, and it typically is not intended to extend to behind-the-scenes assistance.
So this sort of maybe clarifies what we mean by communication or appearance, right? Because we usually say that there's safety in behind-the-scenes communication.
Right.
But what this is getting to is maybe a case in which a former official sends an intermediary with the intention that that communication be received as if it was from that former official. So we're saying basically just because someone carries the letter for you or delivers the message, if we're all to understand that the message is from you,
right,
the fact that you didn't literally do the uttering doesn't make it not a communication.
Exactly. That's it precisely. And this may seem like it fuzzies the line a little bit to the behind the scenes assistance. I think it's really intended to just make sure that former employees don't get cute and get too literal with what constitutes a communication.
This seems to be a provision to prevent abuse.
Exactly.
So if, for example, I was a former government official, everyone knew I worked for the company, and I always sent my assistant to deliver remarks on my behalf. That's the kind of cuteness or workaround that we'd like to prevent.
Exactly.
Okay, that makes sense.
Now we have an example of this, and it's example 5 to paragraph D. And I alert you to that example because this whole concept of sort of third-party intermediary being a concern was something that was addressed by the Office of Legal Counsel in an opinion that they issued to OGE. And example 5 is sort of an anonymous type of version of the OLC opinion, reflecting the OLC opinion that we got. So this one sort of, I think, takes that whole third-party intermediary concept to kind of a place where I think you're going to want to be on top of example 5. Let me put it that way. So it says, a former employee established a small government relations firm with a highly specialized practice in certain environmental compliance issues. She prepared a report for one of her clients, which she knew would be presented to her former agency by the client, okay? So the former employee has prepared this report, given it to a client, knowing full well that the client was going to give that report to her former agency.
To the agency, okay.
Okay? Now, this report is not signed by the former employee, but the document does bear the name of her firm.
Okay.
Okay. The former employee expects that it is commonly known throughout the industry and the agency that she is the author of the report. If the report were submitted to the agency, the former employee would be making a communication and not merely confining herself to behind-the-scenes assistance, because the circumstances indicate that she intended the information to be attributed to herself. So that, it just gives you a sensibility about the subtlety of the nature of how you could engage in, at least according to the Office of Legal Counsel, a third-party intermediary or like a communication that you do not necessarily give entirely directly.
No, and I think this makes sense, and it is a complicated balancing act. And I think, from the perspective of an ethics official, it's a little frustrating not to have that bright line that says, as long as you don't sign or say, you're not communicating. But the alternative, as this example points out, is that, well, I could set up a consulting business comprising me and maybe one other person, and then simply attribute the communications to that business when everyone knows that that business and myself are the same.
Exactly.
Right. And it would just be a simple workaround that would take away all of the substance of this prohibition. So, the alternative is sort of absurd, even though it requires us to use some judgment in the application of these provisions.
Exactly. And if you're interested in the citation or the reference to the OLC opinion, in the Federal Register notice that I gave you, it's actually discussed under the Subpart B prohibitions in the preamble, which is on page 36172. That's on 36172. We have a paragraph that talks about the OLC opinion. You can also find it on our website. The date of the opinion is January 19th, 2001. Again, that's January 19th, 2001, and it's an OLC opinion that you can look at. That's really the cause for that sort of clarification of third-party intermediary in the definition of communication. Okay, so we know the employee can't make these communications either directly or through a third-party intermediary. But what about an appearance? What do we say an appearance is? When do you make an appearance?
A former employee makes an appearance when he is physically present before an employee of the United States in either a formal or informal setting. Although an appearance also may be accompanied by certain communications, an appearance need not involve any communication by the former employee. So we don't even have to say anything at the meeting. Is that what this is saying?
That's exactly what this is saying. So this is saying your physical presence, the employee's physical presence in the presence of other government employees, there are circumstances in which that can be deemed enough in and of itself without a peep out of the former employee to constitute, an appearance that could be in violation of 207.
Interesting.
Now, I don't want to go into it here today, but I do want to let you know that when we get to, that we do talk about, when we talk about intent to influence, because the appearance or communication isn't enough. The appearance or communication also has to be with the intent to influence. And the intent to influence piece has got to be, there are certain times when you could be making a communication and it wouldn't be with the intent to influence. There are times when you could appear before government employees and there wouldn't be an intent to influence, and the intent to influence has to be there. So when it comes to an appearance absent a communication, we have an entire section under intent to influence that talks about what are the indicia, like what are the circumstances in which one might be deemed to actually appear and be deemed to be appearing with the intent to influence. And we're not going to have time to really cover those today, but I do want to alert you to the fact that they're there. We're typically going to see these types of things come up in the context of former senior employees. So we could actually sort of hop on this one a little bit more when we do our next exercise. We can spend a little bit more time on appearance with the intent to influence because it's more amenable. That conversation is more amenable to the other fact pattern that we're going to be debriefing tomorrow. But just to sort of alert you to the fact that is part of the intent to influence piece. So. Okay, so we have to look at intent to influence, and I want to just touch on this just kind of briefly because we've got quite a bit more to get through. And if we don't get through everything today, we'll finish up tomorrow before we start in on the next exercise. But the intent to influence piece is at 2641.201E. And the intent to influence, I think, is kind of obvious, I think, in many respects, Patrick. It's, you're intending to influence, or if you're seeking a ruling, you're seeking a government action, an approval,
a benefit, some other discrete action. That makes sense.
Yeah, I mean, you want something from the government.
Right. You want the government to do or not do something, to grant you something, or to otherwise influence.
Yeah, or persuade them of a certain course of action over another course of action.
Right.
So the intent to influence piece really, as in terms of how it's defined in the reg, is maybe not terrifically helpful. But then we have this whole laundry list at E2 that talks about when intent to influence is not present. And in many respects, what OGE attempted to do here was to give you a list of things that we, as a matter of policy, had already decided and had, so it's almost like,
So rather than just giving the criteria, we said, look, these are some things that people always ask us about. We've looked at them. We've decided they don't constitute an intent to influence.
exactly. So we thought just codify it because we know as a matter of policy, we've already said these things.
Excellent.
So some of them are, if you're just making routine requests for information that would otherwise be available to any other person who communicated with the government, that's not going to be an intent to influence, because anytime you're just asking for something that any member of the public, or you're requesting something that any member of the public could request or seek,
right,
you're not intending to influence.
No. Okay.
Making factual statements. This one is very slippery. Because facts are slippery things, and your facts are not necessarily my facts, and we throw them around a lot. So,
and I think the last part here is interesting regarding matters that are not potentially controversial during the regular course of performing a contract.
mm-hmm.
So this has to be away from the controversy or any controversy that might exist. So if we're merely delivering the facts, there were 3 of these things that arrived today, or
mm-hmm.
We delivered 5 boxes at such and such time, those
Right.
kinds of facts. But if there's anything controversial surrounding that, we need to be more careful.
Exactly. So I think that what you really need to know there is that we're talking about really hard data, things that are non-controversial, things that are non-adversarial,
Right.
and those kind of things are not.
Right, but saying something like, we believe that this thing fulfilled the requirements.
Right.
Right. Someone may say, I believe that is a fact, but that may in fact be controversial, and those might be separate kinds of facts. If you said there were 3 of them, fine. If you said these 3 satisfy the requirement as we understand it.
Yes, because you're substituting your judgment for the action that the government is actually probably in the position to have to take,
right?
Just to make that determination.
You're actually offering an opinion. You're saying,
right.
We think this is a that.
Right.
Right. Yeah. So that's a tricky one.
Signing and filing the tax return of another person as a preparer. We've long said that being a preparer of a tax return and signing it, the signature in and of itself does not constitute an intent to influence. But what's the problem with that, Patrick?
Tax returns sometimes have a way of coming back up after the preparation and filing.
Mm-hmm.
In the case of an audit or something where you might be asked to represent someone in that proceeding.
Right. So anytime you're going beyond just, sort of like signing as a statement of fact that you're the preparer, and then you have to go into actually representing on the content of the return, or any form that would be similar to a tax return, then you're getting into intent to influence.
I always like to read merely into the beginning of that sentence.
Yes. Yes. The remainders are really not ones that are, I mean, they're so specific. I mean, if you're going to be the principal investigator on a grant, or if you're filing a securities and exchange form, I mean, I don't want to go through the whole litany here. It's enough for you to know that there is a laundry list here, but I did want to point out 7, which is 5(2)i, which is purely social contacts, because I think people misinterpret this. When we talk about purely social contacts, what we mean is that the content of the conversation is purely social. We don't mean that the contact is taking place in a bar, so all holds are off and you can talk about anything as long as it's in a social environment.
It's about the content of the communication, not the forum.
Exactly. Exactly.
Right. So we could very well engage in business discussions in a social environment, right? We could be at a bowling alley discussing contract work, and that would certainly be prohibited. There's nothing magic about being in a bar or a restaurant or a bowling alley or at a golf course that says 207 doesn't apply.
Right, exactly. So it's not the venue that counts, it's the content of the conversation that matters.
Right. So inquiring about a former colleague's, wellness of their family or something like that would be social in nature. Right.
So we want to let Ken know you're not going to be able to be the point person on this wellness investigation in terms of, and I would argue with Ken, I don't think we would even want to parse this out and say, well, you could call and ask for a document that's publicly available, or you could call and just talk about. When it comes to, if you've identified a specific party matter where there's a 207A1 restriction, don't let them play fast and loose or cute with it, and don't you do that either. We really don't want to parse this too closely. If we know someone has a prohibition, it's like, just don't call us, don't talk to us, don't appear before us.
And again, we're always doing this without perfect knowledge of the future facts. So what we want to give Ken is some indicia about when he might need assistance determining whether or not proposed activities would be permissible.
Right.
Right. So we don't want to say to Ken, well, social contacts are okay. He misunderstands what we mean by that and then goes forward with the communication. We'll say, before you communicate on this matter, please talk to us and we can help you determine if there's going to be a problem.
Right. Right. So let's go to or before an employee of the United States. So who is it that Ken can't communicate with? who is it that we're concerned about having Ken make these appearances or communications with the intent to influence in the context of this investigation, this wellness investigation? So if we go to 2641.201F, and that tells us who it is pretty much that we're talking about.
Yeah, so that's pretty broad. It says an employee of the United States means the president, the vice president, and any current federal employee, including an individual appointed as an employee or detailed to the federal government under the IPA, who is detailed to or employed by any agency. So an employee of an agency, independent agency, of the executive, legislative, or judicial branches. So that's pretty broad. Also a federal court. Or a court-martial.
Right.
So that's virtually anyone in the employ of the federal government.
Except it does not include members of Congress,
right,
or their staff.
Okay, so the legislature.
So, well, but not entirely
not
the
the
legislature. And this
legislative-
is the interesting thing here, is that effectively it's covering the entirety of the executive branch. So that you
Yes.
definitely know. We're dealing with any agency of the government, including corporations, which is going to be like in the executive branch. Okay, but for purposes of the legislative and judicial branch, we're looking at independent agencies there as well. So if you have independent agencies of the legislative or judicial branch,
so is this like the architect of the Capitol or the government printing office?
right?
So those are legislative agencies, and they fit into that agency category.
Right.
Wow.
Right. So it's a weird sort of, it's the only carve out for the legislative branch really is members of Congress and their staff. So if Ken wanted to go up to the Hill for whatever reason and talk to people on the Hill about the congressmen or staff people about this wellness investigation, he could do that. But let's say that Ken goes up to the Hill to have a meeting with a staffer.
Okay.
And representatives from the Department of Health and Human Services have also been invited to that meeting.
Well, those people are covered.
Those people are covered. So could Ken participate in that meeting?
Well, it says to or before, so he doesn't have to be intending to communicate with them directly, but he would be before them in that case, I think we'd say.
Yes. So that's where you want to make sure that your employees understand that if there is ever an opportunity and they've got a post-employment restriction with respect to a matter, that they shouldn't feel that, again, it's not the venue, it's like who's there, who's going to be in that venue.
So in that meeting on the Hill, they're
Right.
executive branch officials, or in the case of the Government Accountability Office,
Right.
maybe they're represented. They're an agency for purposes of this restriction.
Mhm.
That's very dangerous, it seems to me. So probably a good place to caution Ken.
Exactly. And so let's move on then to on behalf of a third party, because again, there's nothing in 207 that restricts an employee from representing him or herself. One is never, ever, ever, under the criminal conflict of interest statutes, prohibited from representing yourself,
Personally, before the government.
Yes. So Ken is always free to communicate with the government on behalf of himself. But when is he communicating on behalf of another person? When are we concerned that the communication is actually on behalf of another? And if we look,
675, bottom of the page.
okay, if you're in the blue book, we have 675. It's
So 201G.
201G. Okay.
So it looks like we have some criteria. It looks like we're acting as on behalf of another, or acting as the other person's agent or attorney if
Okay.
the employee is acting with the consent of the other person, whether expressed or implied. And so we have to satisfy, it looks like, both of these conditions. The former employee is acting subject to some degree of control or direction by the other person in relation to the communication or appearance.
So the thing I want you to be really careful when you're reading this is that the employee is acting on behalf of another person if they're acting as the person's agent or attorney, as those legal concepts are understood, agent or attorney, okay? Or, so there's a third degree of agency here, and it's more of a common law understanding of agency that is present in this third thing. So if you're acting as an agent or you're acting as an attorney, you're definitely acting on behalf of the other person.
Okay, that makes sense. So those are sort of slam dunks.
Yes.
But there are two other criteria.
Right.
If we meet them, we are still
Exactly.
Yes, on
So we
behalf
have
of.
these additional criteria that are more like common law understanding of what constitutes agency. And that's if you're acting with the consent of someone, whether that consent is implied or explicit,
right.
and
And
you're acting subject to some degree of control or direction by that person. Okay, so those things are things that should be present in order for us to determine that you're actually communicating on that other person's behalf.
So our process is a slam dunk if you're acting as someone's attorney,
Mhm.
right? If you're their lawyer and you're representing them, you're clearly representing on their behalf.
Mhm.
Likewise, their agent.
Mhm.
Or if you are acting with their knowledge and acquiescence and control.
Right.
Right.
Some degree of control.
Some degree of control.
And it's in paragraph 2I that I think we get some real clarification about, because I think we all have some sort of commonsensical notion of what we think on behalf of means, because on behalf of is, you just look in Webster's, it's got, obviously it's got multifarious ways of expressing itself and being understood. And so we really clarify in paragraph 2i what it doesn't mean. Okay. So we say a former employee does not act on behalf of another merely because his communication or appearance is consistent with the interests of the other person, that it's in support of the other person, or that it may cause the other person to derive a benefit as a consequence of the former employee's activity.
So simply agreeing with someone else or having an opinion that's concurrent or similar to someone else and expressing that view is not acting on their behalf. There have to be these two other things, or you have to be acting as their agent or attorney.
Exactly. So it's just important to recognize that sort of subtle distinction in that third sense of agency, but it actually is going to capture, I think, more informal types of relationships that people have with third parties, where they may very well be considered to be acting in an agency kind of capacity for purposes of 207.
Right. So this is another place where it's important to consult the regulation, look at the totality of the facts, and make some good decisions. So again, we want to provide our employees some warning of when they might need more guidance.
Exactly.
Excellent.
One point I did want to make with respect to that, and this is getting back into the preamble, and this is going to come back to our contracting world, because it seems to be in contracting world where we have a lot of pushback in these kinds of areas.
Right.
And one of the things that has come up and was addressed in the preamble to the final rule, and it's on, let me find it for you. It's on page 36175, and it's under the section on behalf of any other person. And this was the circumstance we faced. It was a comment that we got. It said, one agency recommended that OGE create an exception to permit former employees to make certain contacts during the performance of a government contract. According to this agency, a former employee who is now employed by a government contractor should be permitted to make communications and appearances before the government during the performance of the contract, provided that the contractor exerts no control over the former employee in the making of the communication or appearance. Under such circumstances, the commenter thought it is at least arguable that the communication is not made on behalf of the contractor. Okay. And OG didn't follow this in the final rule. We say a contractor's employee is fulfilling his or her duties as an employee when performing the work of the contractor. Under such circumstances, OGE cannot avoid the conclusion that the contractor's employee is acting on behalf of his or her employer. So what OGE is saying here is, when you have a former government employee who has gone to now work for a contractor or work for anybody, by virtue of that employer-employee status that they have with that outside organization,
we're going to punch both of those two criteria. There's definitely a degree of control there.
Exactly.
Right. And that control.
And we're saying it's inherent in the employer-employee relationship.
Right.
That when you have an employer-employee relationship, anytime you are performing work as an employee of that organization, you are by definition doing it as an employee of that organization, e.g. as an agent of that organization.
I think that's very sensible, especially in the context of the kinds of behaviors we're trying to prevent in the case of the post-employment law.
So arguments that, well, the government benefits from this or the government's paying for it and really aren't the interests of the government and the contractor the same, those are all immaterial, OGE is simply saying, look, just as a matter of like legal construct, if you're an employee of an organization, every time you do perform for that organization, you're doing so as an agent of that organization, irrespective of who benefits from your communication or the intentions or any other thing.
I think that makes sense.
Okay. So the only other thing that we would need to do in terms of determining for our employee Ken is whether or not there was any exception that would allow him to make certain communications or appearances, notwithstanding that he otherwise would appear to have these A1 restrictions. Tomorrow, I think I'm going to walk you through some of those exceptions in conjunction with our next exercise. But for today, sort of take my word for it, there aren't any exceptions that our employee could avail himself of.
Excellent. Well, I think this has been a fantastic introduction to these two restrictions, and I agree with what you said yesterday, which is that this is a lot easier to tackle in practice than in theory, and having this structure has been really helpful to sort of understanding the numerous elements of the prohibitions.
So tomorrow we're going to be doing the exercise, which is the email from Mary Carlisle, and I'm going to ask you to use a worksheet again, the worksheets again, to walk through the facts that Mary has given you. We'll pick up tomorrow. I think we might open it up with allow you to ask some questions from today first thing tomorrow, and then we'll proceed to debrief that exercise and take questions as we walk through that.
Excellent. Well, thanks very much, Cheryl. Thanks for joining us, and thank you all for joining us, and we look forward to seeing you tomorrow at 12:30.
Thanks very much.